The second case on our docket today is Martha Moon versus Philip Morris USA. Counsel for appellant, if you're ready, you may proceed.
Thank you and good afternoon, Your Honor. And Your Honors, may it please the court. My name is Jeff Mansell. I represent the appellant, Martha Moon. I'd like to reserve 5 minutes for rebuttal. It's probably aspirational, but if the yellow light goes off, then I'll know where I am.
So noted.
We ask that this court reverse the order of the trial court dismissing counts 1, 2, and 3 of the second amended complaint with prejudice because that complaint states valid claims for negligence and negligent design, strict liability for product defect and design defect, and for failure to warn. As detailed in our briefs, there are numerous decisions of Florida appellate courts, the Supreme Court, this court, other district courts of appeals that have upheld verdicts or reverse directed verdicts based on the same theories of product defect that are in this complaint. In fact, the cigarettes that Martha Moon smoked have been found to be defective in prior cases, and those findings have been upheld. And there is no prior case in Florida that I am aware of that has upheld the dismissal of claims like this on the pleadings. It is certainly possible that there are cases finding that the evidence is insufficient for either summary judgment or to sustain a verdict, as in this court's Nelson opinion, but there is no prior decision finding that these are invalid theories of product defect or of negligence. The trial court found to the contrary, believing it to be bound by this court's decision in Nelson. This was error because the Nelson opinion from this court does not contradict those holdings from prior cases. It does not find that the theories of defect in this case or in those other cases are invalid under Florida tort law. The Nelson opinion is based on a failure of proof. And in particular, as the opinion opens, I would best just quote from the opinion itself, if I'm going to refer to it. Because the jury rendered a general verdict as to the negligence claim, in reversing, we address the lack of evidence establishing causation for both the negligent design and failure to warn theory. Further, the failure to establish causation based on the alleged design defect requires reversal on the strict liability claim. That decision does not require that a trial court dismiss a case like this on the pleadings.
Let's talk a little bit about Nelson specifically with regard to the inhalability holding. There seems to be a pretty broad language in that opinion about the fact that tobacco is inhalable, cannot be a product defect because that is the whole purpose of cigarettes, to inhale them. So could you address that and why your complaint sufficiently alleges a claim beyond that that's different than just pure inhalability?
Yes, of course, Your Honor. Thank you for the question. There is a discussion in the Nelson opinion about the role of inhalability and the role of nicotine in the existence of a product defect. This court's, and Your Honor, Judge Rowe, you're uniquely qualified to talk about what the Nelson decision says. I believe you concurred in the opinion in that case. My reading of the opinion is that this court found the evidence to establish only that the cigarettes the decedent smoked in that case were, in fact, inhalable, that is, capable of being inhaled, and they did, in fact, contain nicotine in some amount. And that proof was insufficient to establish either a product defect or to establish that a product defect caused the smoker's disease and the death in that case. As we've pointed out, our reply brief is a little bit more specific than the initial brief in quoting verbatim the allegations of the complaint. But what the complaint alleges in this case and what the Engel proof was and what the proof was in other non-Engel cases is that the cigarette companies in manufacturing these cigarettes did not merely maintain the inhalability of tobacco when they rolled tobacco in paper. In fact, the complaint is very clear. The defendants in this case did not create these cigarettes by merely rolling tobacco in paper. Instead, what they did was they introduced chemical additives, chemicals and additives into the cigarettes and manipulated the tobacco before rolling them in the paper as part of their engineering and design process to make them more inhalable. And while it may seem like inhalable and more inhalable is maybe a splitting of hairs, it is not, because it is part of the process of making cigarettes addictive. we forget sometimes because, I am 45, and the world that I was born into had these cigarettes manufactured by these defendants. We forget sometimes that there was a time when these defendants did not control the market of cigarettes. Cigarettes have existed for a very long time. They were not like these cigarettes. And even when these cigarettes were on the market, there were other cigarettes that were not like these cigarettes. They too were inhalable. They were not as inhalable. If they were more inhalable, they would be more dangerous, as these cigarettes were. The process of making them more palatable and more inhalable is not just to please the consumer. It is to create addiction. It is to make the cigarettes more dangerous than they otherwise would be. And that's why we highlight, the use of the comparative more in the complaint. This is a deliberate design choice that the defendants made, and it's a deliberate engineering process that they go through with these brands of cigarettes, in this case, Marlboro, Winston, and Newport, that make them more inhalable than other cigarettes. And I understand, as I reviewed the answer brief, the defendants note that the complaint does not say more, quote, than other cigarettes. However, it does say more inhalable. I think a fair reading of the complaint is that when it says more inhalable, it means more inhalable than they otherwise would have been, more inhalable than other cigarettes.
And this more inhalability, you've sufficiently alleged specifically caused this plaintiff harm.
Yes, because as the complaint alleges, the defects in the cigarettes, which include the increased inhalability, the increased nicotine concentration, the increased nicotine delivery of these cigarettes, all cause the plaintiff to become an everyday smoker, an addicted smoker. I don't think the complaint, again, uses the word addicted, but habitual everyday smoker. And it's alleged that she became a habitual smoker in the 1960s, very early in her life. So,
and I just want to go back on one more point on inhalability. Would you agree that under Nelson, if the allegation were merely alleging that this was an inhalable form of nicotine, that under Nelson, that claim would not be sufficient to proceed beyond a motion to dismiss? Simple inhalability.
I think that it's a difficult question to answer for me because there seem to be sort of two alternative holdings in that case. And I think the dominant holding is the causation question because there's a statement that even if this proof satisfied product defect, we do not find the evidence sufficient to sustain a verdict on causation. So it's a close question, Your Honor. I would say that it's not a material question in this case because the complaint does not merely allege that cigarettes are inhalable, and in fact the manipulation of inhalability is not the only material allegation of product defect in this case. Nicotine manipulation is actually, I think, more important in proving the defect, and I think the Nelson opinion leaves that very open as a theory of product defect. I believe that when this court wrote Nelson, it wrote that the proof was merely nicotine content, not nicotine manipulation, and the proof of causation was merely medical causation, that is, that smoking caused cancer, which doesn't tie everything together. The defect, the negligence, the failure to warn all has to tie into disease causation. So to circle back to your question, I think it might be insufficient if we allege they're inhalable and therefore defective, but that's not what the complaint says, Your Honor.
All right. And well, turning to the manipulation of the nicotine and nicotine content, and recognizing this is a non-Engle case, specifically that is an allegation in Engle. Are you aware of any appellate court decisions where, on a motion to dismiss, an allegation of manipulation of nicotine would not be sufficient to state a claim for strict liability?
As I said at the outset, I'm aware of no cases that have held any allegations to be insufficient on product defect in a cigarette case. I am aware of the Arnitz and Whitney decisions which discuss the proof of defect at trial, and in both of those cases it was found to be a valid theory of product defect, and those were necessary conclusions in both of those opinions, as the defendant was arguing in both cases that we're being held liable essentially just for putting cigarettes on the market, and we can't be held liable for the mere sale of cigarettes. That would be preempted under federal law. And then both this court in Whitney and the Second District in Arnott said, no, you're not being held liable for merely selling cigarettes. These are not just the inherent qualities of tobacco being put on the market. These are manipulated products that are more dangerous, than other cigarettes. And for those reasons, the evidence was sufficient in both Arnott and Whitney. And if the evidence was sufficient there, then certainly the allegations are sufficient here. I'm going into my rebuttal time, but I would be remiss if I did not at least mention the failure to warn claim. The sole argument by the appellees regarding the failure to warn claim is that we did not allege causation, and we clearly did in this complaint. We alleged that due to the failure to warn, Ms. Moon became a habitual smoker during that period in the 1960s before the warning labels were preempted by federal law, and that due to her becoming a habitual smoker and continuing to smoke after that date, she developed disease. That's sufficient to at least allege causation by sufficient ultimate facts. If there are no more questions, I'll save the remaining 4 minutes for rebuttal.
Thank you, counsel.
Thank you, Your Honors.
May it please the court, Victoria Powell for the defendants' appellees. This court held in Nelson that designing cigarettes so that they are inhalable and contain nicotine is not a defect. And in fact, this court went on to say that had cigarettes not contained nicotine or not been inhalable to the typical smoking consumer, that would be a design defect. Despite this court's clear holding, the complaint here is chock full of allegations that the cigarettes are defective because they contain nicotine and because they are inhalable. These allegations fail to state a claim for design defect in light of Nelson. Now, Ms. Moon argues that she has alleged that her cigarettes are more inhalable. But this court in Nelson already held that inhalability is not a defect, and that precludes Ms. Moon's theory here.
Why? Explain that. Inhalability and saying something that's more inhalable to make the product more addictive, why aren't those materially different allegations?
Because inhalability is not a defect. The making a cigarette more inhalable is also more of its inherent trait is not a defect. It's simply like, it's like saying that wine is defective because it's more drinkable. The fact that it's drinkable is what makes it, is an inherent attribute. So the fact that a cigarette is inhalable is an inherent attribute.
Let's take your analogy though. If it's more inhalable and it makes you smoke more, or if wine contains more alcohol and it makes you drink more, why isn't that materially different than just a product that is drinkable or inhalable?
Well, first of all, I think inhalability just simply is not a continuum. Certainly, the plaintiff hasn't alleged that here, right? She has not alleged there's this continuum of inhalability, and here the cigarettes are much more inhalable than an ordinary cigarette. In fact, if you look at the allegations in her complaint, in her reply brief, she points you to paragraph 127I of her complaint. And that paragraph tells us that if a tobacco leaf were simply wrapped in paper, it would produce a smoke that is too harsh to inhale. In other words, according to Nelson, it would create a product that is not a cigarette because it's non-inhalable. And then she says that defendants did certain things to that product that made it more inhalable or easier to inhale. So her comparator is simply a non-inhalable product. In other words, what she's alleging is that defendants did what it took to make their products inhalable. And that's what this court said in Nelson is not a defect. The fact that we made our cigarettes inhalable, it just means that we made the product that is a cigarette rather than a different product, a cigar.
But the allegations also go into like the pH level in the smoke and the precise engineering of the pH level to make it as palatable and easily inhalable as possible. So isn't that more than just baseline inhalable? You know, there's a little bit more to the allegations than just it's inhalable.
All of those things are just what's done to make it inhalable. If those things were not done, according to the allegations in the complaint, the product would be non-inhalable.
I don't think that's right. I mean, if you look at the next paragraph from the one you just cited, subsection J, the defendants manipulate the pH levels to allow smokers to more easily inhale the smoke. Not just to inhale it, but to more easily inhale it.
Correct. And taken with the paragraph right before that, it's more easy to inhale than a product that would not be inhalable. In other words, than that tobacco leaf wrapped in paper.
That's not what Jay says. Jay's talking about manipulating the pH levels to the levels they desire to allow smokers to more easily inhale. That's different than what the allegation in I is. I don't think that those are, you can collapse those two things. They've made a specific allegation in that next paragraph.
Well, certainly they don't allege that the cigarettes are more inhalable than an ordinary cigarette, or that they're outside the range of normal. At a minimum, Nelson has to mean that cigarettes within some normal range of inhalability are not defective. And the plaintiff here hasn't alleged that these cigarettes here are outside the range of a normal, ordinary level of inhalability. Nor has the complaint alleged that a minimally inhalable cigarette would not have caused the harms that the plaintiff suffered here, and that it was some extraordinary inhalability that caused her injury. And that's what would be needed to allege a non-inherent defect of inhalability if this court recognized there is such a defect. It's our position that inhalability is not a defect, period. But even if this court were to recognize that, it would have to be outside the ordinary range, and the plaintiff would have to allege that it was that extra level of inhalability that caused her injury. The plaintiff also argues that they've alleged a design defect of nicotine manipulation. So just turning to that design defect, the complaint uses words like nicotine manipulation, but the plaintiff again does not allege that her cigarettes contain nicotine levels outside the ordinary range of ordinary cigarettes.
What case or statute would require them to do that? I mean, let's go to another paragraph in the complaint, paragraph M. Introducing chemicals and additives into the design of the cigarettes allows a chemical reaction to occur to free the nicotine compounds and accelerate the effects, the potency and speed in which the nicotine is delivered. So it's pretty specific on the nicotine manipulation allegation. Where has this court or another said that in the complaint it needs to say, and that's different than your run-of-the-mill cigarette? And what is the standard for establishing the run-of-the-mill cigarette?
Nelson says that an ordinary cigarette is not defective, so I would say it's an ordinary cigarette. And I would point this court to the Florida Supreme Court's decision in Murata, because that's where we get that an ordinary cigarette, defendants can't be held liable for selling ordinary cigarettes. And in Murata, the court said it was not, that the defendants, the Engel class had not alleged a theory of that all cigarettes were defective. They had alleged that the cigarettes contained manipulated levels outside of an ordinary cigarette. So defendants were not just being held liable for selling, for all cigarettes that were on the market. And here we don't have an allegation the nicotine manipulation differs from an ordinary cigarette. And then on causation, Nelson explains that the plaintiff has to show that it was nicotine manipulation rather than just nicotine alone that caused the smoker's injury. That's the ultimate fact that the plaintiff has to plead. And Ms. Moon does not allege that fact. She does not allege that it was non-ordinary levels of nicotine that made a difference in her life that caused her to have her injury. And so she's failed to comply with Florida law connecting the defect to her injury. Instead, the complaint contains shotgun allegations that the defect caused the injury. This is tantamount to an allegation that the product itself caused the injury, because the defects that she alleges here are inherent attributes of a cigarette. It's particularly important for Ms. Moon to allege in this case that nicotine manipulation caused her injury rather than nicotine alone, because the complaint here is chock full of allegations that the cigarettes are defective because they contain nicotine. So this is running headlong into the problem this court identified in Nelson, where it has to be the case that the plaintiff shows that it's nicotine manipulation rather than just nicotine alone that caused her injury. We simply do not have that here.
But I mean, I guess, and this is what I'm struggling with Nelson. Nelson really was, it's after a full trial, it's reviewing a jury verdict. It's really, the holdings are read in the context of was the evidence sufficient or not. And this is a motion to dismiss, where we're just assessing whether the complaint complied with Rule 1.10, is it, ultimate plain statement of the facts that are going to be proven, so to state their claim. And you're wanting us to read Nelson as foreclosing all these things, but even you concede in your answer brief that it doesn't foreclose a nicotine manipulation. And it's a pretty detailed complaint. There's a lot of allegations, and I'm just struggling with you urging us to read Nelson as foreclosing all these things and imposing all these requirements on what she should have alleged when it's kind of grounded in the context of what evidence was presented in that trial. And here, the plaintiff hasn't even been able to present any evidence or proceed. So, help me with that.
Sure. So Florida has a fact pleading standard, which is of course higher than the notice pleading standard in federal court. So I think that the way to read the complaint here is to, in light of Nelson, is to say, if the plaintiff could prove every factual allegation in her complaint at trial, let's just assume that she could prove that all the factual allegations are true at trial, would that be enough to entitle her to relief? And Nelson tells us no on a few grounds. One, inhalability is not a defect. And here she's alleged a defect of inhalability. Two, Nelson tells us that we need to have a showing that it was nicotine manipulation rather than nicotine alone that caused the injury. And here, first of all, we don't even have an allegation that it was non-ordinary levels of nicotine that were present in the defendant's cigarettes. And then second, there's not an allegation that it was nicotine manipulation rather than nicotine alone that caused the injury. That's not an onerous standard. This court's decision in Nelson came out several months before the plaintiff filed her most recent complaint. She had, it dealt with the exact same claims that she's asserting in a non-angle case like the one here. And the plaintiff had an obligation to plead a claim that was different than the one that this court said was not sufficient in Nelson. And she didn't do that here. If the court doesn't have further questions on the design defect, I'm happy to answer more questions on design defect, but if not, I can address the failure to warn claim briefly. Okay, so as to the failure to warn claim, again, Nelson tells us that a plaintiff has to show that the smoker would have, if adequately warned before 1969, stopped smoking, quit smoking, or in some way avoided their injury. And in Nelson, the only evidence on causation showed that the smoker continued to smoke for decades after receiving an adequate warning. The allegations in the complaint here are remarkably similar. The complaint here is devoid of any allegation that had Ms. Moon received a different warning before 1969, she would have heeded that warning and avoided her injury. And in fact, the only factual allegations that we have on causation are, like in Nelson, that Ms. Moon continued to smoke for decades after she received an adequate warning in 1969, and that she quit in 1990s successfully, apparently the first time that she tried. So like in Nelson, there's no allegation here that would suggest that Ms. Moon would heed a pre-69 warning. And that's what's lacking here. If the court has no, I'm happy to answer any further questions. If the court has no further questions, I'm happy to give my time back to the court.
Thank you, counsel.
Thank you again, Your Honors. I will begin by noting that manipulation is by definition not inherent. Manipulation is by definition not ordinary. If you manipulate something, you are changing what is inherent in the product to make it something different. That dovetails into, I think, something important about Nelson, that it must be read in connection with the Aubin decision by the Supreme Court, because of course, I'm sure this court did not rewrite the law on product liability when it decided Nelson. And product liability law is not cigarette law. It is a much more general law in Florida. The Aubin decision is relevant for two reasons. It establishes the consumer expectations test that a product is defective if it does not perform as safely as an ordinary consumer would expect. Consumers' expectations about things other than safety are not relevant to the consumer expectations test. The test is, did it perform as safely as the consumer expected? And the product in Aubin was a manufactured asbestos product called Calidria. And the defendant in that case raised an eerily familiar argument that basically all it did was take asbestos out of the ground and put it in a bag. And asbestos is inherently dangerous and it can't be held liable under design defect for a product that's inherently dangerous. And the Supreme Court rejected that and said, no, you manufactured this product. You took the asbestos out of the ground and made it into something that you put in a bag and sold to people. And that product was more dangerous than the ordinary consumer would expect. And that is exactly what the complaint alleges in this case. They took something that was inherently dangerous, they engineered and manufactured it in a way to package it to the consumer where the consumer, the ordinary consumer, would not expect it to be as dangerous as it was. And that is why the complaint states a claim for product liability
Well,
under
I think you're responding to exactly one of the arguments the appellee is making, is that there doesn't seem to be an allegation that even though you've argued manipulation, and we've talked about some specific paragraphs, you haven't said that it's more inhalable or more manipulated or manipulated vis-a-vis an ordinary cigarette.
Yes, and I just disagree. The complaint says that it was manipulated. If it's manipulated, it is different than the non-manipulated version of the cigarette that existed before they started manipulating it.
Didn't manipulation come up at all in Nelson? Maybe I misunderstand what happened in Nelson. Didn't,
Yes.
wasn't that specifically addressed?
Um,
Or at least it was specifically part of the case. I'm not sure.
It
if
was
the-
definitely part of the case, Your Honor. What the court held, in my recollection, and it's sitting way over there right now, but my recollection is that the court held that there was no expert testimony or other testimony that would have allowed the jury to say these attributes of the cigarette are what caused the disease. And on that point, regarding the allegations in the complaint on causation, you know, the Nelson opinion discussed in both design defect, negligence, and failure to warn the evidence that could have sustained a verdict. You know, if there had been evidence that, you know, this failure to warn affected her, you know, at this time and caused her to smoke, then yes, it could have sustained a verdict, but that evidence was not there. The complaint doesn't plead evidence, it pleads ultimate facts. And the ultimate fact is that because they did not warn her of these dangers, she became a habitual smoker and continued smoking, and that led to disease. So there will be a time to test the evidence and whether the evidence bears out that ultimate fact that's alleged in the complaint. That time has not yet come, Your Honors. There are other things to discuss. I don't think the comparison to alcohol holds very well. I think, you know, maybe a more apt comparison would be if somebody engineered wine to contain more alcohol but somehow not get you drunk so that you drank more and got disease. Maybe that would be analogous to what we are talking about here, because the manipulation here was not just to please the smoker but to get them addicted and get more carcinogens into them and cause cancer. And we are not required to allege the existence of an alternative universe where cigarettes were made differently and Ms. Moon did not get cancer. We are only required to allege that due to these defects, this negligence, this failure to warn, she did smoke and she did get cancer. I am 5 seconds over. I appreciate the opportunity to present oral argument. I thank you all for your attention, Your Honors. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.